chapter chair of YMG, my dear Yemi. Yemi, good afternoon. Yemi, good afternoon.
Good afternoon, Prof. Good
All right.
afternoon.
Can I answer on his behalf?
Okay. Right.
I was waiting for my turn.
Moderator is 5 minutes past 1. You said we should wait for 5 minutes.
Yes.
Can we start?
Good afternoon. Good afternoon, Prof. Good afternoon, Leonard Silks and colleagues, Leonard seniors. I believe we will start. The YMG chair, Abuja chapter will begin. Yemi, are you on the line?
Yes, I am. Just waiting for two people to just join in because I don't want anybody to miss out on this. That's why. So we're starting in the next 1 minute exactly. Yeah.
Yemi,
Yemi,
why? Said 5 minutes.
Okay, so let's. Yes, I also want to ensure that everyone is around so that we don't leave because it's Prof. We don't get Prof every time, so I don't want anybody to miss the opportunity of hearing Prof. So I do a lot of backroom follow-ups. So in no time we'll start.
My national YMG chair is here.
Good afternoon.
Good afternoon. Yeah, moderator, I think you can start. Yemi. One of our qualities as lawyers and specialists should be punctuality.
Yes, I agree with you, Prof. I agree with you entirely.
We should start.
I think 5 minutes, even 7 minutes is enough. It's more than enough.
Yeah.
All right. Good afternoon, everyone. It's a pleasure to have you at this webinar series. May I, first of all, welcome all senior administrators that are here, the branch chair, the YMG Nigeria chair, the Abuja chapter chair, our Prof that I disturbed so much to be here and did not say no. Immediately I asked Prof, he said, when? Yemi, when? When should we do it? Okay, should we do it this day? Prof, we're very grateful. Thank you to everyone. Thank you to the Abuja chapter executives for giving us the opportunity for YMG to have this webinar today. The webinar is titled Unfiltered Arbitration Series. So it's a series that will have several arbitrators, senior arbitrators, come in and give us their unfiltered experience about arbitration. The idea is for young people to understand what people that are experienced to get a proper perspective of arbitration. There's been a lot of misconceptions about arbitration and how to get the appointments, how to do this, how to do that. But when you hear it unfiltered, and that's why we're very deliberate with the team on Filtered Arbitration Series. So it's 60 minutes. I encourage everyone to sit down, relax, have your pen, your paper ready to listen to the one and only Professor Paul Idornigie. You don't want to miss out on anything. That's why I kept saying that I was going to want everyone to join in because Prof is Prof. Prof is in his cadre, on the cadre by himself, and we are so delighted to have him join us today. Thank you very much, Prof. Thank you again to my chapter chair for the opportunity. Thank you to the YMG chair for ensuring that this also pulls through. At this point, I'll just say everyone to listen and learn. Arbitration is beneficial, and this is one of the means by which you can get proper exposure, better experience, and have a better understanding of how arbitration works from the master himself. So, ladies and gentlemen, at this point, I will be handing over. I'll be calling to give our opening remarks the YMG Nigeria branch chair, Abisoye Fadaunsi, for our opening remarks. My chairman.
Good afternoon, everyone. Good afternoon, NSUs. Good afternoon, the speaker. This is a very, very rare opportunity, and we're very grateful to you, Prof. It's my privilege to congratulate the YMG Abuja chapter on this unfiltered arbitration series. It's an excellent initiative, and I'm sure this is going to promote the practical learning, the meaningful dialogue, and professional development of most of us young arbitration practitioners. And let's remember that as young professionals, we grow not only through the formal training, but also through the candid discussions like this that will challenge our thinking, broaden our perspectives, and prepare us for the realities of the practice. Today, I'm particularly delighted that the session features Professor Paul Idornigie, whose wealth of knowledge and experience in arbitration will always undoubtedly provide valuable insight to all of us. And I'm commending the YMG Abuja chapter for this commendable initiative. And I will encourage every one of us to actively engage. Please, let's ask questions and make the most of this learning opportunity. So on behalf of the YMG Nigerian branch, I wish the program a success, and I look forward to many more impactful editions of this session. Prof, I have my notepad and I'm waiting. Thank you, everyone.
Thank you very much, YMG Nigeria branch chair, for the support and for the goodwill message. I'll be handing over to my own chair, my chapter chair, who always says yes to me. I am very grateful, Ms. Roslyn Wusu, for our remarks. My chairman. I'm guessing she's having please call up, or if you can
let me call her.
She was on the call now.
Is the fault from here? I'm not hearing her.
Yes, I was trying to get a hold of her, sir. But she was here now.
Okay. You know, unless I can go, unless she says I should go, I cannot go. Because I'm a man under authority.
Can you hear me, please?
Yes, ma.
I muted myself. Can you hear me?
Yes, ma. We can hear you, ma. Welcome, ma.
Okay, you can hear me now. So sorry,
yes,
I didn't know I was muted. It's my pleasure to warmly welcome all of you to today's Young Members Group Abuja Chapter Program. On behalf of the Executive Committee of the chapter, I extend our sincere appreciation to every participant, our distinguished speaker, invited guests, and especially our young professionals who have taken the time to be here. The Young Members Group remains one of the most important platforms for nurturing the next generation of dispute resolution professionals. Today's program reflects our chapter's commitment to equipping young practitioners and students with the knowledge, practical skills, and professional network required to thrive in the ever-evolving field of arbitration and alternative dispute resolution. As we all know, success in arbitration is built not only on academic knowledge, but also on continuous learning, mentorship, practical exposure, and meaningful relationships within the profession. I therefore encourage every participant to engage actively throughout today's session. Ask questions, share your perspectives, connect with fellow members, and make the most of the opportunity to learn from our distinguished resource person, whose wealth of experience will undoubtedly enrich our discussions. I wish to express our profound gratitude to our speaker, Professor Paul Idornigie, Chartered Arbitrator, SAN, our teacher and mentor, for graciously accepting the invitation to share his expertise. Prof is a rare gem who rarely says no and is always available to help share knowledge despite his very, very busy schedule. Your willingness to mentor and inspire the next generation is deeply appreciated by us. We do not take you for granted. I also commend the Abuja Chapter Young Members Group Steering Committee leadership led by Babayemi Olaniyo for their dedication and hard work in organizing this program. To our young members, I encourage you to see today's program not merely as another program, but as an investment in your professional future. The relationships you build, the knowledge you acquire, and the inspiration you receive today may very well shape your career for years to come. As a chapter, we remain committed to creating opportunities that promote excellence, encourage innovation, and foster the highest standards of professionalism amongst our members. We look forward to seeing each of you take advantage of these opportunities and to contribute meaningfully to the growth of arbitration and ADR in Nigeria and beyond. Once again, I warmly welcome you all and wish you a productive, engaging, and rewarding program. As I said, I have my pen and paper with me because I know we are going to learn so much. So I hope you are doing the same. Thank you and God bless you.
Thank you very much, Mar. So without further ado, I would recognize other guests when they come in. I'm going to be handing over to the moderator of this session, Mrs. Emokinovo Dafe Adekpeye. She's going to be taking us through this interesting session. It's a question and answer session with Prof. And Emokinovo is who she says she is, a very astute legal practitioner and arbitrator with years of experience, and is doing so well in the arbitration space. So, Emokinovo, the mandate has now been given to you to ensure that we finish within time and have a wonderful time. Thank you again, Prof, for the opportunity to be here. Kinovo, over to you.
Thank you so much, Yemi, and thank you to the YMG Abuja chapter, of which I'm a member, for this opportunity. We're in for a swell time, Prof and I. Prof wears many hats. He's a teacher, he's a senior advocate of Nigeria, a chartered arbitrator, and a member of the Permanent Court of Arbitration at The Hague. So this is going to be an interesting time, and you're in for a really swell ride. So, Prof, without further ado, because we have a lot of questions and we have limited time, I would like to kick us off with the very first question. Now, as I said, your career spans, the full traverse of legal practice, academia, litigation, arbitration. Specifically in relation to arbitration, what drew you to arbitration and what has kept you passionate about it till this moment?
My dear Mokinovo, good afternoon. Good afternoon, everybody. I am really glad to be here.
Good afternoon, Prof.
Yeah. Let me start by appreciating the CIAB, the chairs in Lagos, the chairs in Abuja, and the young members group. One thing that the YMG do not know about me is that at Veritas University, where I teach, they call me the Gen Z professor. The Gen Z professor. So really, I am one of you.
That is interesting.
I belong to this group. Now, let's come to the two-legged first question. I see myself as privileged in many ways in this area. I first trained as a chartered secretary and administrator before I read law. That was the first time in 1984 that I studied commercial arbitration. I came across many cases, but one case struck me called Bremen, Vulcan, and South India Corporation, where Lord Diplock held doors. And I quote him, "Respondents in private arbitrations are not entitled to let sleepy dogs lie and then complain that they don't bark." That quotation was a major attractor for me. This was a case where the claimant went to bed. He was not prosecuting his case. And the respondent kept quiet. He did nothing. He didn't report to the arbitrator. Then some months later, the respondent filed a motion to terminate the proceedings. And Lord Diplock said, both of them have corresponding duties to ensure that there is proper prosecution of the case. So you cannot allow sleepy dogs to lie and complain that they don't bark. I find that very, very interesting. Now, what kept my passion? The second arm of the question. When I was teaching at the University of Jos, I had time for litigation. I was going to court. In 1997, I joined the Nigerian Law School. We were staying in Buhari then. I could not come from Buhari to Abuja to go to court. So I said to myself, what do I do with my legal practice? I resorted to arbitration. So the fact that I can conduct arbitration privately and now virtually has sustained my interest in this area. Now, let me quickly add that in this session, in this conversation, there's a lot to unpack. I hope that we will not apply for extension of time, but I am told that the moderator is a very strict monitor that she won't let me overshoot. I'll try not to overshoot. You recall that some of you at the law school, CIAB, came to teach arbitration at the law school. And I used to be on the faculty. And anytime I had cause to introduce myself, I introduced myself as an evangelist, winning souls for arbitration. Now, we have warned you. What do we do with you? We have warned you. What do we do with you? Today, I am still an evangelist and a farmer or sower, sowing on different soils. If you are a Catholic, you remember the homily last Sunday. It talks about the parable of the sower. I also call it the parable of soils or the parable of the farmer. So at the end of my presentation, I will ask you, what type of soil are you?
Thank you so much, Prof, for that insightful introduction. And just as I've learned from you, we cannot allow parties to extend time, inundately. So, Prof, I'm sorry, the application may not be granted by this honorable tribunal. But Prof, just let's stick with your starting point. Just looking back now with your illustrious career, you mentioned 1984. I mean, you can't be Gen Z and be talking about practicing law in 1984. But looking back from that time, what would you say are the pivotal decisions that shaped your journey to becoming one of Nigeria's leading arbitration practitioners?
I always like that question. People ask me how I started. Now, I think that obtaining a doctorate degree in international commercial arbitration shaped my journey. Conventionally, most of my friends moved from litigation to arbitration. In fact, we had a program in, I think, Kigali on this same issue of how did I start. I always argue that I started from the top. Whereas others start from the bottom, litigation, they do entry court, they do. I had a PhD in commercial arbitration before I started. And so I can approach arbitration from different perspectives, from practice, from academics. So I am not just an academic arbitrator, but a practicing arbitrator at the highest level.
Thank you, sir. And just like you said, everybody has their path, and your path was to being a teacher, was to get a PhD in something you knew you wanted to explore as a career. Now, of course, now we have Chartered Institute of Arbitrators in Nigeria that train many of us to become whether associate, member, fellow, and the like. But beyond this, obtaining this certification, in today's world, as a Gen Z professor, what qualities would distinguish a promising young arbitrator from the pack?
You know, this is a fast lane generation. Like you said now, from 1984 till how many years? So you see me now, you want to be like me. But my advice always to young arbitrators is that they should start by being tribunal secretaries. They should not aim at being arbitrators immediately. They qualify either ACIS, MCI, or fellow. They should aspire to be tribunal secretaries, or we'll call them a clerk, we'll call them registrar, to appreciate how arbitration is conducted before looking for the initial appointment. Secondly, they should learn to be interns working with competent, I want to underscore the word, competent arbitrators as a stepping stone. If you work with an incompetent arbitrator, it reminds me of a priest. The priest was taught by a priest who was epileptic. So when the epileptic priest is saying mass, he will be vibrating. So when the apprentice became a priest, anytime he was saying mass, he was shaking like his epileptic priest. So you must try and learn from a competent arbitrator. Now, you can also offer pro bono services to arbitrators to learn the ropes. Now, your initial appointment should not be that of a sole arbitrator or a presiding arbitrator. No, you should aim to be a co-arbitrator so that you will learn from, again, I'm hoping that the presiding arbitrator is competent, because if you are working with an incompetent, with due respect, presiding arbitrator, you are in trouble. Qualify as an arbitrator and a lawyer. These two things are not enough. They are necessary, but they are not sufficient conditions. Now, subject matter expertise is very, very critical. What the Arbitration and Mediation Act teaches you is the practice of arbitration and the rules, how to conduct a hearing. That law does not teach you substantive law, especially your law of contract. I'll give you one example. I did an arbitration. I was sole arbitrator in the matter. A consultant was engaged to collect money nationwide, and they agreed on a percentage they will pay him. He collected so much money for the organization. They were to pay him 50% before. They said, no, they will pay him 5%. They wrote to him, and he started by saying, without prejudice to our contract, we now intend to pay you 5%. And they paid 5%, and he said it was final. It was a matter before me. Now, you have to understand your law of contract to know the meaning of without prejudice. Without prejudice. In fact, one of my friends said that 5% was a dash because it's without prejudice to the contract. The contract says 50%. So after paying him that 5%, they are still owing, no. I said, no, I will not take that out myself. They are owing him 10%. They should pay him 10%. So you should, if you have finished university, which you have finished, but you are not strong in your law of contract, when you have any arbitration, look at the area. If you're not graded in the area, please try and read up the area. You must have subject matter expertise. I urge young arbitrators to keep updating their skills in emerging areas. AI is there. Construction arbitration is there. Indeed, for a place like Abuja that I see Abuja like a construction site. So I urge many arbitrators to become members of that body. We have oil and gas. We have investment treaty arbitration. We have maritime arbitration. So many areas you can specialize in. Because for me, just being a commercial arbitrator at the moment may not be sufficient. You must show that you have a special skill somewhere. Don't forget, law school, last year, they produced over 5,000. This year, they just produced over 6,000. They will soon join you. So you must show that you have a special skill that others do not have. For instance, if you are interested in investment treaty arbitration, you must know the 3 laws of investment treaty, like treaty, like statute, like contract. Why am I talking about this? We all know as arbitrators that the agreement to arbitrate is very fundamental. There must be an agreement to arbitrate between the parties. But in these 3 areas, treaty, statute, contract, you do not need any agreement. In the case of the treaty, you are relying on the bilateral investment treaty. In the case of statute, look at the NIPC Act Section 26. That draws a line between local contractors and foreign contractors. And it says, if you are a foreign investor and you have a dispute with Nigeria, you can resort to arbitration. That is seen as a study offer, or a contractor provide for investment treaty arbitration. Now, if you are lucky to have an early break in your career and you get an appointment, when I'm approached to be an arbitrator, I remember Section 8 of the AMA that provides that when you are approached, you must disclose all justifiable doubts that can lead to your independence and impartiality. So once I'm contacted, I quickly do a conflict check on the parties, on the subject matter. And I always insist on seeing the contract before I accept appointment. Because I've seen instances where a contract provides for a tribunal of 3, they just appoint 1 person and they go on. And I've seen instances where a contract provides for the one arbitrator to be appointed by one party, another by the other, detailed by an umpire. In our law, there's nothing like an umpire in AMA. In the UK, yes. So you need to read the contract to know the nature of jurisdiction that you have. Now, I refer to Section 8. Unfortunately, Section 8 does not describe instances where you must disclose. So you must know hard law and soft law. Soft law like IBA conflict rules. IBA conflict rules draws a line between, not between, well, it's broken down into 3 areas: the red list, the green list, and the orange list. So you should try and read the IBA conflict rules to know instances that where you must disclose. You should know too that your appointment can be challenged. It can be challenged if, for instance, it can be shown that you are conflicted. 2, if the contract provides for qualification, you do not have the qualification, your appointment can be challenged. Before you accept the appointment, now, when you accept the appointment, you prepare what we call a preliminary meeting. That is the first contact between the arbitrator and the parties. You must know how to conduct the preliminary meeting. And that is where you confirm your jurisdiction. You also make your full disclosure and get the parties to confirm that you have jurisdiction to conduct the hearing. At the end of the preliminary meeting, you will issue a procedural order. Again, if you have a competent tribunal secretary, it should give you a first draft of the procedural order. Now, I talked about internship just now. There's pressure on me for internship, for mentoring, and all that. I had a reference. I got 3 interns. I said, okay, you come. And when I have interns in a hearing, I do more of teaching than conducting the arbitration, because I try to explain to them what I'm doing, why I'm doing it. I told the interns that in my practice, if I conduct a preliminary meeting on a Friday, by Monday, I should publish the procedural order. In other words, you work throughout the weekend. So we had this meeting on Friday. I told the interns, you will give me a draft procedural order. Saturday, I didn't hear from them. Sunday, I didn't hear from them. Monday, I told the registrar, write to them that if they do not give me a draft procedural order, That is the end of the internship. Out of the three, only one responded. The two did not respond. Now, if you are in my position, will you engage the two again? Will you even let them? Because see, the challenge with many young arbitrators is opportunity to watch. That's a major challenge, to be given an opportunity to see a senior conducting arbitration. Now, one is given this opportunity and is abused. As an arbitrator, you must remember Section 30 of the AMA that deals with your duty to the parties to treat them equally and give them a reasonable opportunity to present their cases. And you must adopt a fair means for a quick and fair resolution of the dispute and avoid unnecessary delay and expense. In practice, what you find, no two arbitrations are the same. I repeat, no two, in fact, I have not found a second arbitration that is like what I ever done before in my life. So that's probably why there is no judicial precedent in arbitration. No two arbitrations are the same. Now, if you are conducting a hearing and you are faced with a novel position, what do? You abandon the hearing. That reminds me of Lord Denny. Lord Denny said, if you are sitting as a judge, a novel matter is before you, no judicial precedent, no statute, do you fold your arms? He said, no. You must extend existing principles. So from your experience of arbitration, you now adopt procedures that will avoid unnecessary expense and delay. You must ensure that the procedure you are adopting is fair to both parties. Now, you must know how to conduct arbitration. This area is not very different from litigation. Then write and publish enforceable. I want to underscore the word enforceable award. It's no use engaging you as an arbitrator and you write an award that is set aside. You must then you know that your award can either be enforced or set aside. Know the grounds. The role of court in arbitration, you must know. The role of court, because if a counsel before you is raising a matter that is not covered by Section 64, you remember Section 64? It says, in matters governed by this act, the court cannot intervene unless as provided by the act. So when a party is raising a matter before you, a counsel, ask him to show you where is rely on in the AMA. Then limitation statute, it applies to arbitration the same way it applies to litigation. Then we now enjoy immunity. I stop here for now.
Thank you so much, Prof. And that was really a loaded answer to that question. I love how you focused on knowledge, because the knowledge is power. So it's one thing to gain certification, it's another thing to get knowledge and specialist knowledge in arbitration and conducting arbitral proceedings. Specifically, you've mentioned using the path of arbitral secretary or registrar as a pathway to learning more within the arbitration forum, and why we need to take mentorship seriously. I think we had this conversation about a week ago where you said it's one thing to get the opportunity, it's another thing to use the opportunity when you get it. So whilst we are, as young arbitrator, you sit as arbitral secretary, ensure that you are diligent, take up the mantle, draft the procedural orders as quickly as possible so that the arbitrator can look over it and correct you, because it's by correction that you learn and you become better in the future. So thank you so much, Prof, for that. So let's move on to now, a young arbitrator has been mentored. He or she has gone through the process of having been arbitral secretaries a number of times. Now we want to move on to that appointment phase. So at what point in the arbitration career does one transition from learning to earning? And how does a young arbitrator know when they are ready to charge for their expertise?
Well, I'll be waiting for this because I know that is the major area of this conversation. Do you know that there's no end to learning? I'm still learning. Do you know that as you feel that I am challenged by you, that is how you are challenged by me? Now, when I studied arbitration, it's not what I'm seeing now that I'm doing. So keep learning. Keep learning. And by the time you become a tribunal secretary, If you serve under me, I ensure that you are well paid. I remember a reference I did that was in euros. I paid my secretary 10,000 euros. I negotiate good fees for my tribunal secretary. So if your watch expert perform an arbitration, then you can transition from being a tribunal. In fact, right now, there's somebody who has worked with me severally as a tribunal secretary. Now this is me as a co-arbitrator. He is very good. He is very good. So see, I always say in this world, all you need is a chance. All, especially me, for someone working with me, like a chance. I send you a mail at 2 a.m. You will reply till 2 p.m. You're out. If I send you a mail at 2 a.m., I expect that if I'm awake at my age, you should be awake. And I'll say to you, wake up. And you cannot collect your money unless you wake up. So you must wake up to collect your money. And you must earn the money working with me. Today, there are many tribunal secretaries that I have used that I will never use again. Never. So try and show that you are competent. Now, it's a learning curve. It may start, your journey to earning may be long, it may be short. It depends on many factors. For instance, who is your mentor? How dedicated are you? How competent are you? What is your station in life? In other words, how is your background? How are you connected? What is your network? All these are factors that will quicken how you progress in this career. Now, we are naturally impatient. For me, it's worse with this generation. I have colleagues who qualified for 10 years, they had no appointment. And yet, they are still paying their subscription fees regularly. But I know just now, it's not possible. If you pay twice, I mean, I always have meetings. Today, the meeting room is full. Tomorrow, you don't say I paid for 3 years now, no show. Like I said, you may be at the intermediate stage of your career where you change and you do not know. Do you know that it is the way you live? So I am also learning. If I go for a session, I look for hot topics in arbitration. In other words, what is new? I'm ready to mentor anybody, but those are methods. Ask them how I work. You know, in Abuja, joy to see my mentees excelling, my students excelling. I go for a conference. I see that my teachers, my students are those presenting papers. It gives me joy. So, like I said, moving from learning to earning is a function of many variables. But I can say to you, maybe you are at the intermediate stage. You are getting close to, I said from the beginning, I said that I'm a farmer and sowing. Maybe it's getting to the time of harvest. And if you follow the homily of Sunday, you will harvest in 100, in 60s, in 30s. Let's go.
Thank you so much, sir. And what I really learned from your response to this question is that knowledge is infinite. We're forever learning.
Yeah.
And just like you said, we all attend conferences. What are we taking out of the conference? What new areas of law are we exploring after we attend this conference? It's not enough just to attend. We need to take something away from it and then go further to explore after those conferences. And then, of course, networking. Your network is your net worth, as they always say. So if you don't network, if you don't have mentors or people that can speak for you, how do you get the first appointment and get from learning to earning? And of course, what you said, you resonated today, is that people must be ready. So it's one thing to have a mentor. It's another thing to do the work as a mentee to ensure that you don't mess up and your mentor is proud to say that, this person is my mentee, and then hopefully appoint the person in the future. Now let's move on a little bit to the process, so the procedure of arbitration in itself. Now, as an arbitrator, you've spoken, Prof, about procedural fairness. You've spoken about equal treatment of the parties, which are all provided for in our Arbitration and Mediation Act. Now, sitting as an arbitrator, how do you ensure that procedural fairness, persists throughout the arbitral process, particularly when you're dealing with parties with unequal resources or levels of experience? I give an example. You have counsel on one side who is trained, understands arbitration, and you have counsel on the other side who you already see the inexperience, you see it in the process. How do you deal with that kind of scenario?
Well, I cannot descend into the arena of conflict. So I'm very mindful. You lawyers are very smart. Generally, lawyers wait for you to goof and use that as an excuse to apply to set aside your award. So I'm very mindful of Section 13 of the Act to treat them equally and give them a reasonable opportunity to present their cases. Now, how do you treat them equally? When in a hearing, it's only one party that's always applied for adjournment, only one person that is coming late, only one party that is delaying, the other is doing nothing. Again, in cost, you can take care of any cost incurred in the course of the hearing. So, for me, it's a balancing act. You must try and be fair to both parties. For instance, I will hate if my award is set aside on grounds of absence of fair hearing. I will hate it. So there was an award I wrote. The respondent was applied for adjournment, was applied to amend. I was granting. At a point, I said to him, this is the last application that I'm granting. Now, we concluded hearing. I told them when my award would be published. On the date the award was published, he still filed an application to amend his pleadings. I ignored him. I published the award. Of course, he went to court to challenge. And one device I use to protect my award is my procedural history. My procedural history. In fact, my procedural history is almost as detailed as the main award. I start from how I was appointed, how many meetings I called, how others were given, how they were obeyed, and so on. I did. In fact, that has saved many of my awards. I had one award. In the reference, I was appointed by the court. The court spelled my surname wrongly. At the preliminary meeting, is the person the court appointed the person presiding? They say yes. Ask them again. Is the person, because they spelled my name wrongly, is the person presiding? They say yes, I recorded it. Guess what? That was the ground for setting aside. The side that lost went to court that it is not the party, it is not the person that the court appointed that conducted the hearing. And my procedural history cured this defect. There's another award I published. Now, the contract was a 3-tiered contract. Amicable settlement, mediation, arbitration. The claimant tried to exploit amicable settlement, tried to do mediation, wrote to the governor, wrote to the attorney general. I have appointed an arbitrator. Appoint your own. In 30 days, they failed to appoint. The claimant went to the regional center, got an arbitrator appointed. The two of them appointed me as presiding. I took over. And anybody tried to play games with me, I always laugh. So I called a preliminary meeting. The respondent came. They came. They left there to file a suit against me in person, to restrain me from conducting a reference. in the AMA, we have section 13 dealing with immunity of a. I wrote to the court that I now enjoy immunity like a judicial officer, unless you can show. I didn't go to court. I didn't go to court, and I published the award. Now, when they applied to set aside conditions precedent, we are not. If you go through my procedural history, you will see how many times, how the process started, how many times I notified them there's going to be a hearing, and I ensure that all processes were duly served on them before I published my award. So really, it's born out of experience how you manage a process. You can also talk about guerrilla tactics. Me to court. There's a matter I'm doing now. We were at the stage of evidential hearing. The first witness was called, cross-examined. Second witness was called. As he was being cross-examined, the respondent realized that he had a weak case. He feigned absence of network. There's nothing he did do to ensure that we didn't continue with the hearing that day. I kept quiet. Later, he sent a text, applied for adjournment, and granted it. The day the matter was adjourned to, he came with an application to amend his points of claim. I asked for the comments of the respondent. Vehemently, the respondent opposed it. And I ruled that application for amendment now is inappropriate and we overreach the respondent. What did the respondent do? The matter involved a parastatal in Imo State. He has sued me personally at Imo State High Court for the court to grant an order compelling me to allow him to amend his pleadings. Have you heard that kind of application before?
Wow.
These are things I face in my practice. He sued me personally. Again, I'm going to rely on section 13. In fact, what they do now, in the published award, instead of apply to set aside an award, they will join me. I said, go and look for the grounds for setting aside. My name is not there. What? Focus official. You are wasting your time if you are joining me in trying to set aside my award. So, what am I trying to say? It's a balancing act born out of experience, how you ensure procedural fairness. But it's a major issue in arbitration. Thank you.
Thank you so much, Prof. And it's interesting you talk about guerrilla tactics. I think one of the issues we've always had in arbitration is lawyers trying to find creative ways to scuttle the process or to set aside an award. And that's why it's very important, as you say, the procedural history. Of course, we know our jurisdiction comes from the agreement of parties. And that's why we need to, unlike judges that have their jurisdiction by law, we need to set it out very, very clearly. And this is one of the reasons why mentorship is important, while continual learning is important. So thank you so much for that, Prof. Now, still sticking on procedural issues, there's been this issue about, obviously, you spoke about the arbitrator's independence and the impartiality and the duty to disclose. You spoke about the IBA guidelines and the rules on conflicts of interest. Now, does this duty also extend to arbitral secretaries? And if so, why?
That is interesting. If you look at the AMA, there's no reference to arbitral secretary at all in the AMA. But there's a document called Uncitral Notes on Organizing Arbitral Proceedings. There's reference to secretaries there and their duty. More profoundly is the IBA complete rule that provides that the duty to disclose imposed on the arbitrator extends to the secretary. Again, if you appreciate what the secretary does, if you appreciate the role he plays, in fact, if you look at critically, if you undertake a training on how to be an arbitral secretary, you find that what is left out for the arbitrator is evaluation of the evidence. It is secretary that drafts the procedural history. It is secretary that says the evidence. It is secretary that drafts the submissions. What he cannot do, the evaluation of evidence. And therefore, he is bound by the same rules that govern the arbitrators in terms of impartiality and independence. So you must tell your tribunal secretary that as you are disclosing, once his or appointment is confirmed, they must also disclose that they are not convicted. Otherwise, your award can be set aside on that ground.
Thank you so much, sir. And this just goes back to the, what you said earlier about not just looking at the hard law, but the soft law, because what you referred to are not legislative provisions. They are soft law, either from the IBA, from UNCITRAL, and it's very important that as an arbitrator, what you said about knowledge, your knowledge has to be expansive and not very restrictive to just your Arbitration and Mediation Act and whatever training we get from the Chartered Institute. So thank you so much for that, Prof. Now I want to move on to mistakes and avoiding mistakes. Now, what are some of the common mistakes you see that young arbitral practitioners make, and how can we best avoid them?
They are too much in the haste. Like the Yorubas will say, or the Igbos, wanyo, 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 or the Hausas, kadan, kada. The mistake they make is that first, we seniors are operating a court, and therefore they are excluded. Another mistake is some will argue that arbitration house court, because the Federal High Court has unlimited jurisdiction. How can the Constitution confer on a judge? He's saying that they have disputes that cannot be referred to them. Now, not many people know of Section 19, I think 19E of the Constitution. That section of the Constitution provides for arbitration, mediation, and reconciliation in respect of international disputes. But it deals with policy objective of the Constitution. So the Constitution itself recognizes ADR processes. So the mistake some people make regarding money is that they think that they can just get ACI, not ACIS, they get ACAB and immediately start making money. I think that's a major mistake. Like I said earlier, you may be lucky. You just finish. Let me also advise that when you work in a law firm that does just litigation and your interest is in arbitration, you're in the wrong place. So you must try and work in a commercial firm, that has commercial transactions. It's from those contracts that a dispute will arise that will go to arbitration. So where, like I said earlier, your station in life, where you work, the friends you keep, the network you have is very, very critical in charting your course. Thank you.
Thank you so much, sir. And just what you were just saying about how you gain knowledge. For me personally, I gain knowledge from being first legal practitioner, advising clients in arbitration disputes. So I first started as counsel. And that's another way that one can gain knowledge and see how proceedings are really, really conducted. So, and that will avoid mistakes because you learn the good, the bad, and the ugly very early on when you are sitting as counsel and not having to make the ultimate decision. So thank you for that, Prof. I just want to say to our audience, if you have any questions, please put them in the comment section. We'll try and take one or two because this is a once in a lifetime opportunity to get Prof here for an hour. So please put your questions whilst the session is going on, and we will try and get to them. Okay, so let's move on to the next question, Prof. You've mentioned that throughout your career, even the way arbitration proceedings are being conducted has changed. Initially, you were sitting, if your arbitration was in Paris, you would have to go to Paris. You have to go to The Hague. But COVID then happened, and of course, we had technology and all that. So from your perspective as an arbitrator that has been in this game since the 80s, how do you see artificial intelligence and emerging technologies changing arbitration over the next decade?
My advice to the younger ones, you must learn to embrace emerging technologies. AI especially. I use it a lot myself. A lot. I use it a lot. You must know that the rules have changed. Now, I have been in my study in the house this morning. I took part in a meeting in the Ministry of Justice. I had to leave the meeting to continue with this conversation. So things have changed. That's why I said I am still learning too. I am trying to keep pace with technology. I'm trying to keep pace with development. When I started, there was nothing like investment dispute arbitration. Nothing. I didn't know. In fact, when I did my PhD in arbitration, I didn't know that there was money in arbitration because I had not seen any arbitrator. I had not taken part in any arbitral proceedings as an academic. I was just doing a PhD in an area. That's all. I was doing the PhD in Jos until I came to Abuja. That's not this thing be. Wow. And when NNPC appointed me in 2010 on a dispute involving Shell, and we started the hearing in the UK, continued from Nigeria, and ended up in Canada. In the arbitration, I was earning £5,000 per day, per sitting day. £5,000 per sitting day. I said, this life, I didn't know that it can be this sweet. And one good thing about arbitration, you are just making money quietly. Litigation, they see you go to court. You know you are doing something. But in fact, I was telling my wife last week, I said that, do you know that the money I make is from my study? Because I used to do physical hearing. I don't know when I did the physical hearing last. All of my hearing now are virtual. So I just stay in my bedroom. If you know what I'm wearing just now as I'm talking to you, you won't believe it. But I'm in the house. All you can see is what I'm wearing on top. Maybe you are like that too. And maybe others are like that too. But see, that is life. It's changing. We must change along. We must change along. Especially the younger ones. I feel for them. I actually feel for them. See, when Patrick Kweto, SAN and I started this business around 2004 in Abuja, we were very few. And there are many references to us. But today, in Abuja, almost every senior advocate is a fellow. Not just an arbitrator, it's a fellow. So for me in Abuja, there are more arbitrators than the available disputes. It's a place like Lagos that is big enough to accommodate, because all those doing arbitration in Lagos, they are all big boys. They're all big boys. They don't have the challenge you have in Abuja. I appreciate that. But like I said, there is consortium going on in Abuja. Try and get close to those who are. You must be active and be vigilant, and say to yourself, where do I go to and have the proper connection to get this dream of mine fulfilled? Thank you.
Thank you, sir. Just like you said, yes, there are new technologies, but whilst you're talking about the challenges, I also think of it as there are merits, there are advantages. You talked about sitting in your house now, and you're able to earn without going outside. You could not have done that prior to maybe COVID days. And it's the same for even young arbitrators. Even when you're trying to get mentorship, now you can be mentored by people that are not even in the same city as you, because if you get the opportunity.
Just a minute. Just now, I'm doing an arbitration at LASIAC. My registrar is in Canada.
Brilliant.
The registrar is based in Canada.
Amazing. And so really,
for an arbitration in Lagos.
Amazing. And there's so many opportunities.
And we have not met. And we have not met.
Wow.
We have not
Prof,
met.
there are a number of people that you need to meet in the comment section. You have so many arbitral secretaries in the comment section as well. But just moving on, because we don't really have that much time. I think we have like 10, 15 minutes left in this session, and it's been such an exciting session. I will, ask about ethical challenges, because one thing that we know in this business is that you are as good as your name and your reputation in this business. Yeah. So what do you think are the ethical challenges, or what ethical challenges?
The ethical challenges
in arbitration, and how should your arbitrators prepare to address them?
Thank God, corruption in arbitration is not anything near, with due respect, corruption in litigation. So corruption is a challenge. I mean, I was involved in a reference. Good money in US, in euro, good money in naira. And the parties tried to reach me. They tried to reach me. And I was just laughing. I said, look, I'm well paid in this reference. And I don't need to be corrupted. I don't need to be rich. I'll give you an example. I said just now that NNPC gave me a reference. Now, in the course of the hearing, NNPC officials were happy with me and they wanted to see me. I said, no, NNPC, you can't see me until my award is published. They couldn't believe it because they appointed me. They reminded me that they appointed me. I said, yes, but you cannot see me until my award is published. In this award, let me be modest, I got over 100,000 pounds. Now, we finished it. We wrote the award in Canada. As I was coming back to Nigeria, I landed at Itro. At Itro, I got a phone call from NNPC. They had another arbitration. They said, the GMB said, that man that refused to see me, give it to him. It shows that he can be trusted. So character, integrity, these are key words in arbitration. You must have them. You must have them. See, money will come when it will. You don't have to fight for it. You don't have to ask anybody who's rich. Efforts he made to make money. No. When it is time, it will be a rainy day. Thank you.
Amazing. Thank you so much, Prof. I like that you focused on the, keeping your integrity, because as you said, you can still earn a lot of money by doing the right thing. So it's not either or. You do not have to be corrupted. And I like that you mentioned about appointments, because many times people believe that if they have appointed you as the party appointed arbitrator, that means you should rule in their favor. But your obligation is not to the party who appointed you. Your obligation is to give a fair award, an award that is credible and enforceable. And thank you so much for that, Prof. So I'm going to ask one more question before we move into the comment section to see if there are any questions. And so my final question would be a final piece of advice. So what's the final piece of advice you would leave for a young arbitrator? And when I say young, I don't mean age. I mean young in the practice of arbitration, who is trying to build a successful and respectable arbitration career.
At the beginning, I referred to the parable of the sower. I will end with that parable. We, the elders in this business, are the sowers. We are the farmers. The seed, the message we are conveying. Then the soil, the young arbitrators. So ensure that you are in a good soil. If you know the story of the parable of the sowers, some of the seeds dropped on a pathway. Some seeds drop on thorny soil, some rocky, some on good soil. And if you are a good soil, in other words, you are a good material, then the material will take root. It will grow healthy and produce massive harvest, 30, 60, even 100 times more than your initial investment. So just now, we are laying a foundation, but keep persevering in hope when things do not seem to be going well for you. Keep persevering. The challenge is between accomplishment instantly versus accomplishment eventually or ultimately. Your accomplishment may not be instant, but I can tell you in this business, ultimately, you will make it. Life is not 100 meters dash. You know that. Life is not 100 meters dash. So don't throw in the towel. Because of failure and disappointment. Like I said earlier, we may just be at the intermediate state. Your ideas will mature gradually. Let them grow. And the last word I want to say to you, give our God the benefit of believing that his hand is leading you, and accept the anxiety of feeling yourself in suspense and incomplete, that the good Lord will lead you and you will excel this business. God bless you all.
Thank you. Thank you so much. And I would like a virtual round of applause for Prof. Thank you so much, Prof. This has been so engaging. And I've learned a lot. I'm sure our participants have also learned. Now, we have just one or two questions, and I would like to take them quickly. We're keeping to time. So, Prof, you as a seasoned arbitrator, you have done very well and you have kept to time. So well done as well, sir. So let's take one or two questions from the comment section. And there's a question here by Mr. or Miss Aziz. And the question says, can one be a singular industry focus from the get-go, e.g. construction arbitrator? So, Prof, remember you mentioned about having specialism. The person is asking, is it okay to just focus on one industry?
Yeah, because you see, commercial arbitration is saturated. What we do, come at this with commercial arbitration. Everybody who has passed the exam is in that area. And like I said, because the market is saturated, you must try and create a market for yourself. For instance, everybody knows me in this country with investment treaty arbitration. I'm not the only one doing it, but everybody knows me when it comes to investment treaty arbitration in this country. People remember me. So as you grow up in your career, I'm not saying you should abandon commercial arbitration if matters in that area before you. But you should be known for a particular area, that you are an expert at construction arbitration. You are an expert at sport arbitration. You are an expert in intelligent dispute arbitration. So let it be that you are an expert in one area, but all of us are commercial arbitrators.
Amazing. Thank you so much, Prof, for that answer. And there's one question from someone from the law school, Prosper. So the person is asking that he's currently in law school. How do I start as a person who is really passionate about arbitration? Must I get a certification to start?
Funny enough, unless a contract provides for qualification, anybody can be an arbitrator. Anybody can be an arbitrator. So in arbitration, we have quality surveyors, we have accountants, we have all kinds of professionals in arbitration. But a degree in law gives you an edge, because if you are an arbitrator, lawyer like me, senior advocates appear before me. Lawyers, and if you're not a lawyer, a senior advocate appear before you, you will feel intimidated. Nobody intimidates me. So you need to ensure that you prepare yourself for your role as an arbitrator. So being at the law school, that's a good starting point. No, but being at the law school is just graduate. Do they have any set now? I think they are just doing call to bar.
They just graduated a set now this July.
Aha. So is there any set there? And I don't think so. I don't think there's any set there now. So this one's telling me it's in law school.
There is.
Oh,
okay.
Yes, I have about 5 of them with me now on
all right.
law office attachment right now.
Yes, there is. They're on law office attachment.
Okay. Well, it's a pity. I'm in Buhari with them and I do not know. It's a pity. Yeah, that's good. Okay. No, I know that there are law students on law office attachment, but I didn't know that. Anyway, it's a long time I left law school, so I'm not following again what is going on there. But if you're at the law school now, try and contact us. We can come to train. In fact, we usually come to train. Get the full details of Mrs. Rosalie Nwosu, who is our chapter chair. She will tell you how CIAB can organize a training for law school. We normally go there to teach them, touch them young. That is where I'm an evangelist, and now I'm a farmer. I sow seeds, and I know that all my seeds are dropping on very good soil, and very soon they will reap massively.
Thank you so much. Thank you so much, sir. Thank you for this awesome presentation, this awesome question and answer session we've had today. As you said, you are a teacher, a farmer, an evangelist, all in one, Prof. And we're really grateful from YMG for this fantastic session. In fact, it wasn't a YMG session, it was just a CIAB session, because we had people from all over joining in, and we had people from all ages and all spans in their career, whether young.
In fact, sorry, somebody joined from Kenya or so.
Yes, I saw that.
Even
from Cameroon as well.
Cameroon. Okay.
Thank you so much, sir. We really appreciate your insights for the time you've taken
So
from
number
your
2 on the agenda is the appointment of the tribunal.
there is
Sorry?
Reduction
Okay,
of the instruments and accounting sole arbitrators. So I have a
Madam
letter
Chair's
here.
hand is up.
sorry, I can't.
2nd of June.
The chairman's
20.
hand is up.
okay. I think
Sorry?
someone else is talking.
That
I
is
think
the appointing instrument.
it's yourself.
Yes. For the respondent, yes.
I think the branch chair, Mrs. Olusola Adegbonre wants to speak.
Oh, Before I told you I'm a man under authority. My chair.
Confirmation.
I'm here.
Yes,
I'm
ma'am.
still here.
Yes, okay.
Yes,
I mean,
yes, ma'am.
not my
Okay. Is
national
it the
chair.
branch chair? Let us
Yes, the
welcome
branch
her.
chair is in. Welcome,
Oh,
ma'am.
that's very gracious of her. Welcome, Madam Chair.
Thank you. Thank you very much. This I
Welcome,
couldn't miss
welcome.
when the moderator, I don't know, Mrs. I have to learn that one now. Our moderator, when she said that everybody is here, young, old, it was very true. You know, I have also really, really learned a lot. You know, I don't use words like enjoy for webinars and seminars. It's not a place we come to enjoy. We come to learn, you know, and I have been really enriched by this webinar.
Very, very true.
Yes.
I have my pen and pencil.
Yes,
And paper,
exactly.
rather.
Exactly. I've been really enriched, and I just want to thank the YMG. You know, I had questions as well, but I said, okay, I can see Prof, I can see Zuo, so I can see everybody and ask questions later. So let me leave the floor. But also, for those who are asking about how to become an arbitral secretary, you can find out, look at our website. We run courses on arbitral secretaries training, on basic introduction. You can also reach out. I think Abuja has a website, or you can reach out to
Yes, we do, and we have a lot of information
so
there.
please put the website on the chat box for them, so that people can copy the website now. Let them have the website on the chat box, and then for trainings on arbitral
if you're there,
secretary,
please put it there, or Hawa.
Please put the website there. I've told I don't know, we'll check when our next arbitral training is coming up. We'll also put it there so that people can have information. Like we've been hearing, knowledge is power, you know. So I want to thank the YMG for this wonderful, I mean, they always have wonderful webinars. This is another wonderful one. And like you said, how you got Prof for this long time is amazing, because Prof, I always tell Prof he should be sleeping at this time, because Prof works all night at 75 plus. So, you know, thank you so much. It's
Madam
been
Chair,
amazing.
Prof is in a class of his own. No, nobody can beat
we
him.
shouldn't copy. We shouldn't try it. at 75, you know, if you are working all night, we shouldn't copy him. And he's really up to date with technology. You know, Prof is using AI. He's syncing between one device and another. You know, I've learned a lot from him, even about technology at his age of 75. So once again, thank you very much. Makinovo, well done. Fantastic moderating. And to all my people
Thank you,
here.
Madam Chair, for attending our program one more time.
So I will, because you always have interesting programs, and I'm happy to attend. I've learned a lot myself. So I just wanted to say thank you very much, and I look forward to the next one too. I just joined from wherever I am, you know, and just make sure I don't miss it. I mean, we're supposed to remember where I was joining from the last time. You know,
Yes, so I do, and we appreciated that.
I will always join, because your programs are always
Thank you so much.
interesting. And
it encourages us to continue to push.
Yes, so please. Thank you very much. So you all have a good evening while we continue, because I'm still online until the press leave. And they say when they say the meeting has ended.
Thank you again.
Yes.
Thank you so much.
Prof, I'll bring my own questions to you personally. Let me not take their time here.
No problem.
I think I'll do the same.
You know, it's
Prof,
a continuous,
thank you so much.
It's a continuous dialogue.
Yes.
Like I said, no one arbitration is the same as the other.
No,
Every
no, no.
arbitration present its own unique challenges. So
Oh yes,
That is
yes.
true. That is true in my
Yes. I tell
experience.
people
Yes.
that UCOS case, I think is the second highest case. The arbitral secretary was an
The
international.
Russian one
Yes, the
Yeah.
arbitral secretary, just the arbitral secretary was an
did
international
everything.
arbitrator himself. An
Yeah.
international arbitrator, a fellow. He did a lot of the work, and that they even consider that maybe he was the fourth arbitrator. So we all keep learning. So if an international arbitrator can be tribunal secretary, because some people say, tribunal secretary, I don't want that. But we're learning and learning. If Prof appoints me as tribunal secretary now, Prof, I'm ready.
Me, I will gladly be one too.
So I will do it
Even
before
without
you, Ms.
payment, I
Uwosi.
will be there.
I am a man under authority. Authority in Abuja, authority in Lagos.
Yes, sir. Double.
Thank you so much. Thank you.
Yeah.
Thank you, Prof. Thank you. You have wowed us as usual, but I'm not surprised anyway.
Yes, we do confirm that. Up there, see what then? Yes, we confirm.
Okay. Thank you very much, Madam Branch Chair. Thank you for always making our time to attend our webinar. We don't take it for granted. Thank you very much, Prof. I'll hand over to Eboluwa Igili to give the vote of thanks so we can draw the curtain in this particular webinar. Thank you, Prof. Thank you, Emoikinovo. Prof, I'll be in your DM.
Good afternoon, everyone.
Thank you, moderator. You did very well.
Yeah.
Thank you so much, ma'am.
Good afternoon, everyone. I'm sure we can all agree that it has been a very impactful and intellectually stimulating conversation on behalf of the YMG Abuja chapter of the Chartered Institute of Arbitrators. I'd like to thank our distinguished guests, Professor Paul Idornigie, SAN, Chartered Arbitrator. We are also deeply grateful to our chapter chair, Mrs. Roslyn Nwosu, FCIAB, and the branch chair
Thank you
for her presence, Mrs. Olushola Adebomire, FCIAB. We also thank the YMG Nigeria chair, Abisoye Fadonsi, and we thank the YMG Abuja chapter chair, Babayemi Olaniyan. We also thank the moderator, who is the YMG Nigeria secretary, Emokinyovo Dafiakpedeye. And we thank all our senior arbitrators, all our learned silks, and all the young arbitrators who joined us. Thank you so much for participating. And we hope to see you all at our next Unfiltered Arbitration series. Thank you all very, very much.
Yes, we are eagerly waiting for the next one.
Thank you, ma'am.
Yeah.
Thank you
Bye-bye,
very much,
everybody.
everyone. Thank you, Prof. Thank
Bye,
you,
everyone.
We're grateful.
And thank you for coming.
Thank you, ma'am.